Set up. All right, are you ready? Great. We're going on the record in State versus Brandon Way. It's indictment 21SC179614. Mr. Way is on a trial calendar that is active right now down in courtroom 1D, a consolidated trial calendar. I submitted this case to that. He's also on our upcoming trial calendar, but I have been told by Mr. Adams, his lawyer, that Mr. Way is prepared to go forward with a plea. Is that correct, Mr. Adams?
That's correct.
Okay, well, Mr. Adams and his client, Mr. Way, are here in court, and we have Ms. Jones-Connor here from the state. Is that correct?
Yes, Your Honor.
Thank you for covering for Ms. Olivier, who was covering for Mr. Abate.
Absolutely, Your Honor.
Appreciate the flexibility. I'm fine having you all stay seated as long as the court reporter can hear you. Are you all right staying right there, Mr. Adams?
Yes, sir.
Okay. Mr. Way, you are charged in the indictment with 3 counts of murder and a variety of related offenses. My understanding is that some of these charges are being reduced. I'm going to let Ms. Jones-Connor get all that on the record. But what I need to make sure you understand is that in a moment, you're going to be put under oath. Once you're under oath, you need to answer all of the questions from the prosecutor as well as from me, honestly and completely. Will you do that?
Yes, sir.
If you have any questions of your own, will you let me know?
Yes, sir.
If you need to speak privately with Mr. Adams, we can get you guys back into lockup, but it's important that you let me know if anything discussed confuses you or is just going differently than what you thought was going to happen. Will you do that?
Yes, sir.
Okay. Ms. Jones-Connor, when you are ready.
All right, Your Honor. All right. Mr. Way, would you please raise your right hand for me? Do you swear and affirm that the testimony you shall give in the matter currently before the court is the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
And you can lower your hand. Can you state your true, correct, and legal name for me?
My name is Brandon Denard Way.
And are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
Is there a medication that you normally take that you have not been given today?
No, ma'am.
How old are you and how far have you gone in school?
I'm 35 years old and I made it to get my GED.
And are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you are charged with the following offenses? And this is an indictment number 21SC179614. For counts 1, 2, and 3, you were charged with murder, which has been reduced to voluntary manslaughter by the state under OCGA, section 16-5-2. Counts 4 through 15 in the indictment have been null pros by the state. And count 16, possession of a firearm by a convicted felon. Do you understand that you are charged with those following offenses?
Yes, ma'am.
And do you understand you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Ms. Jones-Connor, just so I'm following. So
Yes,
a plea to the first 3 counts reduced to voluntary and then count 16, possession of a firearm by a convicted felon.
That's correct, Your Honor.
Got it.
And Mr. Way, have you had enough time to review the waiver of rights form with your attorney, Mr. Adams?
Yes, ma'am.
Okay, and did you understand all of the statements that were listed in that waiver of rights form?
Yes, ma'am.
Okay, and on the last page, we have a signature on page 4. I'm going to approach you with that. And do you confirm that that is your signature?
Yes, ma'am.
Okay, and the date on which that has been signed would be today, April 10th, 2023. Is that your understanding as well?
Yes, ma'am.
Have you had enough time to speak with your lawyer, Mr. Adams, about all the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes, ma'am.
Are you satisfied with his services?
Yes, ma'am.
Do you need any more time to discuss the case with your attorney?
No, ma'am.
Counsel, do you waive formal reading of the indictment?
We do.
And do you waive any and all defects in the indictment, the state knowing none?
We do.
Now, Mr. Way, I have to ask this for the record, but were you arrested on the charges that I listed out in this indictment?
Yes, ma'am.
And the state is unaware of any outstanding warrants that are related to these charges. Do you know of any outstanding warrants that are related to these charges?
No, ma'am.
Okay, and counsel, are you aware of any outstanding warrants that are related to these charges?
I am not.
Mr. Way, has your counsel advised you of the minimum and maximum sentence for each charge you are pleading to? That being for counts 1, 2, and 3, voluntary manslaughter under OCGA section 16-5-2, anywhere from 1 year up to 20 years to serve. And for count 16, possession of a firearm by a convicted felon. I apologize. 1 second, Your Honor. So, Your Honor, I apologize. The notes mentioned something a little bit differently. Can I have just a second to speak with Mr. Adams about
Sure.
And Your Honor, I misspoke on behalf of the state. Count 16 is actually possession of a firearm by a convicted felon, but under OCGA section 16-11-133, the state was amending that to OCGA 16-11-131B.
Okay, which gives us a range of 1 to 10?
Yes, Your Honor.
Okay.
So that would give a range of 1 to 10. And Mr. Way, do you understand that the state is amending that charge 16, possession of a firearm by a convicted felon, to possession of a firearm by a convicted felon, but under OCGA 16-11-131B, and that carries anywhere from 1 year up to 10 years to serve?
Yes, ma'am.
Okay. Now, do you understand that this is a negotiated recommendation that is being provided to the court with your plea of guilty, which means that the state will provide that recommendation to the court, but the court does not have to accept that recommendation. The court can sentence you up to the maximum on each charge and can run those sentences consecutively, meaning one after the other.
Yes, ma'am.
Okay. For the record, the state's recommendation for count 1 is 20 years to serve 6 years, that balance to be served on probation. The special conditions of probation are that you have no firearms, that you stay away from the family of all victims, and that you waive any Fourth Amendment rights. For the record, that is the family of Cortez, Cortez, Watkins, Watkins, the family of Bernard Watkins, Bernard, Watkins, and the family of Alfonso Hall, Alfonzo Hall, Hall. And is that the recommendation as you understand it for count one?
Yes, ma'am.
For counts 2 and 3, the state would ask for the same recommendation under voluntary manslaughter, that being 20 years to serve 6 years, the balance to be served on probation with the same special conditions as count 1, and for counts 2 and 3 to both run concurrently to count 1. For count 16, possession of a firearm by a convicted felon under OCGA section 16-11-131B, the state would recommend a sentence again of 10 years to serve 6 years, that balance to be served on probation, the same special conditions of probation as counts 1, 2, and 3, and for count 16 to run concurrently to counts 1, 2, and 3. And do you understand that to be the negotiated sentence?
Yes, ma'am.
And do you understand that this is a guilty plea which is permanently recorded on your criminal history?
Yes, ma'am.
And do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including the federal courts?
Yes, ma'am.
Do you understand that if you are currently on probation or parole, your probation or parole may be revoked based on your entering a guilty plea today?
Yes, ma'am.
And do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of your sentence?
Yes, ma'am.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes, ma'am.
And do you understand that if you are not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction at a trial would, and that this is true regardless of any advice by your attorney or anyone else?
Yes, ma'am.
And do you understand that neither the court, your attorney, nor the district attorney's office has anything to do with parole, the Department of Corrections, or Board of Pardons and Paroles, and no one can guarantee parole no matter what anyone has told you?
Yes, ma'am.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial? For example, your guilty plea may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment. Do you understand that?
Yes, ma'am.
And do you understand that by pleading guilty to a felony today, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will be guilty of a felony, which may carry a sentence of 1 to 15 years in prison?
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a guilty plea today?
Yes, ma'am.
And do you understand that by pleading guilty, you are giving up these following rights: the right to trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at the trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial. Do you understand that you are giving up all of those rights by pleading guilty today?
Yes, ma'am.
And do you have any questions about any of those rights that you're giving up to plead guilty today?
No, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea today?
No, ma'am.
And is it your decision to waive these rights and enter a guilty plea because you have decided that it is in your best interest to do so?
Yes, ma'am.
Okay. And it's the state's understanding that you are pleading guilty under North Carolina versus Alford. Is that correct?
Yes, ma'am.
Okay. And are you aware that even if you do not admit guilt, this is a plea of guilty, which places you in the exact same position as if you were convicted by a jury at a trial?
Yes, ma'am.
How do you plead to the charges of 3 counts of voluntary manslaughter under OCGA 16-5-2 and 1 count of possession of a firearm by a convicted felon under OCGA 16-11-131B and indictment number 21SC179614?
Guilty.
And again, is that guilty under North Carolina versus Alford?
Yes, ma'am.
Okay. And is this guilty plea freely and voluntarily given with full knowledge of all the charges against you?
Yes, ma'am.
Do you understand that you have 30 days in which to appeal your conviction based on your plea today?
Yes, ma'am.
And do you understand that you have 4 years from today for felony charges to file what's called a habeas corpus petition, which challenges the voluntariness of you entering this guilty plea today?
Yes, ma'am.
Your Honor, as far as a factual basis for this case, the facts of the case relate as such that on October 5th of 2020, officers were dispatched to multiple people being shot upon a call. Upon arrival, officers located multiple people who had been shot. All victims were transported to Grady for further evaluation and treatment. It was a short time later that it was learned that 2 of the victims were deceased and the third was rushed into surgery. Later on that same day, the third victim did pass away as well. The responding officer told lead detective Hogan, Hogan, that there was only one shooter. Detective Hogan did find 10 large caliber shell casings at the scene. And as he attempted to leave the scene, he was stopped by Sierra, Cierra Hunter. Ms. Hunter stated that she was the girlfriend of Cortez, Cortez Watkins, and that she was with him a few blocks north of the incident at 951 Coleman Street, Atlanta, Georgia, in Fulton County. Mr. Watkins was there to purchase a gun and test fired the gun in an empty lot across the street. After he fired that gun, he was approached by the defendant, Mr. Brandon Way. Mr. Way started an argument with Mr. Watkins and Ms. Hunter, and then she stated that they have had a long history of aggression due to an old grudge over some drug transactions. Ms. Hunter stated that Mr. Way threatened the life and well-being of Mr. Watkins many times previously, and she also stated that on the night of the murders that occurred October 5th, 2020, Mr. Way initiated an argument and stated, "You better be here when I get back," to Mr. Watkins. Ms. Hunter then told detectives that Mr. Way appeared to be on something at the time, referring to drugs, and everyone agreed to just leave at that point. However, it was later that same evening that Mr. Way returned, walked right past 951 Coleman Street, in a black coat, looking as if he was concealing something as far as her account. There was also surveillance video that was pulled from a neighbor's camera that showed similar Mr. Way walking in a black coat, appearing to have been concealing something. He's pacing, waiting for Mr. Watkins to return, but then he walks south towards Welch Street, Welch. A few moments later, the shots fired call comes into APD. Your Honor, it was through the investigation that officers were led multiple times to Mr. Way, but there are some hurdles that the defense and the state have talked about with this case. This is not something that we take lightly, but due to the fact of where we stand with the evidence and in light of the entire investigation that was done not only by Atlanta Police Department, but then subsequently by the Fulton County District Attorney's Department as well, we did come to this negotiated resolution. We do have family of the victims present as well. They have been spoken to in regards to how we ended up at this resolution. We understand that this is not a desired resolution from anyone's standpoint. However, in light of everything, we would ask that you would accept it as negotiated. As far as Mr. Way's criminal history, I don't know if you want that from me, Your Honor, or from.
I do, because I don't know that we've got anyone plugged in right now. But before we get there, I appreciate that your office has worked hard on this case. Mr. Abate has shared with me that he's worked closely with the family members of the Watkinses as well as Mr. Hall. And I'll talk a little bit later about the difficulties of processing something like this. I need a little bit more as to what connects Mr. Way to this right now. I understand that there was a long-running dispute between Cortez Watkins and Mr. Way, but we have 3 people who were shot and died, and I didn't hear anything about what connects Mr. Way to Bernard Watkins being shot and killed, and Alfonso Hall. And so I know you're new to this case, or newer, but I can't accept even an offered plea. I may not accept an offered plea as to the killing of Bernard Watkins and Alfonso Hall if there isn't something more than, well, we found 2 other bodies lying next to Cortez Watkins.
Absolutely, Your Honor. I apologize for that. I do have further information in regards to that. So after the events on October 5th, 2020, and Detectives Hogan's investigation there that began with Ms. Hunter, he later on October 12th of 2020 interviewed Kenton, Kenton Watkins. And Kenton is the brother of Bernard Watkins, who's the second victim who passed away 13 days after this October 12th date. He is also the cousin of Cortez Watkins. Now, during Mr. Kenton Watkins' interview, he stated that he was familiar with the feud between Mr. Way and Mr. Cortez Watkins. And he stated that on the night of October 7th, 2020, he received a call from Michael Cain, C-A-I-N, who is the brother of Mr. Way. And when he received that call and during that conversation, Mr. Cain stated that he wanted to squash the incident and avoid any retaliation. Kenton Watkins stated the whole conversation was done under the assumption that they both knew who was responsible for all of the murders. Mr. Cain assured Mr. Kenton Watkins that he was not involved with the murders, but he never denied that Mr. Way was involved with all of the murders. Detective Hogan then reached out to Mr. Cain, who denied a portion of the conversation that happened, but eventually the defendant was arrested for the murders of Mr. Hall, Mr. Bernard Watkins, and Mr. Cortez Watkins, and he was found at the apartment of his girlfriend at the time. In regards to the connection that evening, one moment. And I apologize, Your Honor. I just want to make sure that I directly answer the question.
Mr. Way, I'm going to ask you a few questions while Ms. Jones-Connor is looking for that. You are always able to enter, a defendant is always able to enter what we call a best interest plea pursuant to this U.S. Supreme Court case of North Carolina versus Alford. It's a scenario when a defendant says, I don't agree with everything the state said happened, but I think given the offer I'm receiving, it's in my best interest, not mine, but yours, to accept the offer and move forward. So you're saying yes to moving forward with the plea, but not necessarily yes to I did all the things the state said I did. Do you understand what I'm describing?
Yes, sir.
And does that describe your situation?
Yes, sir.
So after I hear a little bit more from Ms. Jones-Connor, I may be in a position to accept the offered plea. Assuming I do, I want to make sure you understand that this will still show up on your criminal history as a conviction. It's not like a first offender where if you do well while you're on probation, it's expunged from your record. It's going to show up as voluntary manslaughter and possession of a firearm by a convicted felon. You understand that?
Yes, sir.
Okay. Understanding all that, it's your intention to enter a best interest or offered plea in connection with the 4 counts that the state is going forward on.
Yes, sir.
Okay.
And so, Your Honor, I just want to make sure I'm saying it correctly, but I believe I stated this earlier. So Mr. Bernard Watkins and Mr. Cortez Watkins are cousins. Mr. Alfonso Hall was a friend of both of the Watkins. And so Ms. Hunter, when she provided her account of who all was together that evening, that is what placed the Watkins together along with Mr. Hall. And then when officers arrived on scene, at that point, when officers arrived on scene, that is when the placement of where everyone was somewhat corroborated. So Mr. Hall was discovered on the east side of the street adjacent to where Mr. Cortez Watkins was found. And then Mr. Bernard Watkins was discovered in the driveway of 1084 Welch Street, Southwest, near the road. And he was the only one who was at that point the lone survivor, but he was not able to speak due to his injuries. But it was from the conversation that occurred with Miss Sierra Hunter that the connection was made between all of the parties, and she added in the background that specifically was between Mr. Way and Mr. Cortez Watkins.
Okay, so there's a motive that the police developed for Mr. Way to be angry with, threatening towards Cortez Watkins. There is the corroboration of Ms. Hunter, as well as some surveillance footage showing Mr. Way back in the vicinity, pacing around with the dark jacket. And then Mr. Cortez Watkins is found dead. So there's a circumstantial case as to that. And then there is these other 2 gentlemen. So Cortez Watkins' cousin, Bernard Watkins, and then Mr. Hall are found dead and then mortally wounded in the same vicinity with the 10 shots fired, and all the shell casings come to one gun. So it's not a gun battle. There is one shooter, and the suspect of shooting Cortez Watkins would be Mr. Way. And so there isn't another gun, another person who would be the suspect for Bernard Watkins or Alfonso Hall.
Absolutely, Your Honor. And also to add into that corroboration of only one person and it pointing to Mr. Way is the statement from Ms. Hunter, and then the statement from Mr. Kenton Watkins with his conversation with Mr.
Mr.
Kane, naming only one shooter.
Okay, I understand it better. I also understand why the state is seeking to work the case out this way rather than the risk of going to trial. So if you would tell me, please, about Mr. Way's criminal history.
Absolutely, Your Honor. One moment. Your Honor, Mr. Way does have previous felony convictions, that being a 2009 possession of a firearm that was 21SC179614 out of Fulton County, to which he did plead guilty on May 24th of 2010. And then he also has a 2010 conviction from May 20th of 2010 for possession of cocaine with intent to distribute. That was 07SC62369, also out of Fulton County. And those conclude the known felony convictions we have for Mr. Way.
Okay, I think someone from probation will be joining the call, and I'll see if she's got any additional information about Mr. Way. Mr. Adams, share with me, please, what, before we do that, Ms. Jones-Connor, were there any victim impact statements that you wanted to share or man, if you don't mind standing up, only so the court reporter can hear you. If you come up and stand by Deputy Gordon, that'll just help us hear you. If you could let me know who you are and to which of the three gentlemen you're connected.
I'm Bernard Watkins' mother.
Okay, thank you for being here.
I just wonder why would he shoot my son if he was mad with Cortez? You know, and I'm sure when he went up there, somebody told him, if you mess with Cortez, you got to mess with everybody up there. That's why he shot my son. And I don't think it's fair that he can get probation and he doesn't kill 3 people. But if he get probation, whatever God will be dead. If he can live with killing 3 people and be happy, I'm happy with it.
Thank you, ma'am. And a couple things. I appreciate you sharing that. You could see I was sort of scratching my head about some of this same stuff. Mr. Way, the recommendation isn't just probation. There is some probation, but it's that he would serve additional years in prison, probably a lot less than you would think would fit when 3 people are dead. But hopefully you've understood a little bit of what I've been wrestling with, which is how on earth would the state prove this case if it went forward? They might, and if they did at trial, then Mr. Way is looking at a life sentence. But if they fail to meet their burden, and the burden's on the state, it's a pretty high burden, then we have someone walk free, and that's a different outcome. So this is a balance. I don't know that it's the right balance. It's certainly nothing that brings the level of closure you might expect. But I appreciate you sharing that. I wouldn't expect you to be enthusiastic about how this is playing out. Good morning, ma'am. If you could tell me how you're connected to
Jill Watkins, I'm Cortez Watkins' mother.
okay, thank you for being here.
I don't understand how I can get that far of a little jealousy of a woman that want to just take 3 life and malice and not just have no sorrow, no, just figure, oh, I'm gonna get away with it, come out on the street and, oh, I killed 3 folks. They ain't do that. You know what I'm saying? You took 3 lives. My son had 3 kids and now they're without a father. And it bothers me so much. I mean, I'm still waiting for him to walk in the door and come back. No, he wasn't a perfect child, but to kill somebody over a woman.
Is that your understanding of what the dispute was? It was over a female?
Yeah, over female Sierra.
Oh, Miss Hunter.
Yes.
Okay.
That's what it was over. And it's, it hurts me so much to be lost my son and his children is without a father. And I am without him. I miss him so much because he was like my backbone. And I just don't understand how you could just take somebody's life, have no remorse, no nothing, and want to just, like it's all right. You know what I'm saying? And just to want to get out here, back in the street and do the same thing. You know what I'm saying? It's like, it should be something more could be done than just walk out and then just go take another life. And just because they couldn't find a gun, everybody know who did it. You know what I'm saying? But just because we couldn't find the gun, yeah, he was gone a long time. They been on got rid of that. You know what I'm saying? It's just, y'all keep saying let it go. I can't let it go. That's my child. That was my firstborn. They just don't understand. It took a part of my heart. You know what I'm saying? We grew up together. It's like, I can't get over it. Still to this day, I still cry and miss him so much. No, he wasn't perfect.
He in the Lord's hand, but I know that. Okay. I don't want you sick. Come on. I don't want you sick.
Ms. Watkins, I'm certainly not asking you to get over it. That wouldn't be a request I'd ever make. You're hurting and you're going to continue to hurt and you're frustrated and you should be frustrated. I think that's natural. And by nothing I've said have I meant to suggest, why don't you all move on? Far from it. What I was trying to share with you and with the woman who preceded you is I'm trying to sort this one out as well. And it's got to be particularly frustrating for you all because of the one thing you shared with me. You said everyone knows what happened. But if everyone doesn't come forward and talk with the police to say I was there or he confessed, then the prosecutors don't have the tools they need to make the case. Because the way you prove a case at trial is you get 12 strangers in there who don't know Mr. Way, who don't know Cortez, they don't know Bernard, certainly don't know Ms. Hunter. And you got to convince them beyond a reasonable doubt that Mr. Way did it. And it's not enough to say everyone knows he did it. And so you know in your heart of hearts what happened here. And I'm getting the sense that I understand what happened. But if there isn't that proof, and it's not just the gun, we do plenty of murder trials where the guy throws away the gun. That's not, but there have to be witnesses or something who are willing to step up. And that's, you got to be brave to do that because the streets, they also remember who talks. So, and I don't share that with you to excuse any of this. None of it excuses it. You hurt and that hole is there forever. When you look at your grandkids, you're thinking of your son. How can you not? And as holidays come, it's Easter and your son's not there, that hurts. My hope for you is that it hurts a little less each year, but I don't ever want you to forget. I don't ever want you to think this was okay. I don't think it was okay. But we work with what we're given. And for whatever reason, in this case, there isn't someone coming in saying, no, I was right there. I saw him do it, or a camera that captured it, or DNA or something. Sometimes those cases happen, and then we have a very, very different outcome. But I don't want you to take from this that somehow the DA's office didn't care, the court didn't care. you can think what you want about Mr. Way. That's a different situation. But again, we work with what we get. I don't expect you to forget. I don't expect you to think this is a healthy outcome. There's not a healthy outcome. Let's say in the end, Mr. Way went to prison for the rest of his life. That still doesn't bring your son back. I'm not saying we need to feel bad for Mr. Way, not at all. But the tragedy has happened, and we can't erase that. What we can hope is that through your friends and family and community, they can lift you up a little bit. And that, I don't know if it's boys or girls, but your son's 3 kids can maybe have an outcome that's better than what happened to your son, because he didn't deserve that. No, there's no someone who deserves killing. That's not a decision for any one of us to make. But then these tragedies happen, and we need to try to pick folks up as best we can. So I appreciate you sharing what you shared, and it's natural for you to be feeling that way. Okay? Thank you. All right. I appreciate you all sharing that. Mr. Adams, before I hear from you, Ms. Tucson is on. Good morning, Ms. Tucson.
Good morning.
Were you able to look up Mr. Way's case to let me know if he is on probation now and if you have any criminal history for him?
Yes, Judge, no problem. I did pull it up. I have it right here. And he is on active probation at the moment with the Atlanta circuit. Would you like the case number?
I would, please.
It is 15SC 136514.
Okay. And how much time remains on that case?
7 years, 3 months, and 8 days.
All right. Let me look that one up. 15SC 136514. There he is. Okay. A case with Judge Glanville. All right. That's the only open one?
Yes, there are 2 previous inactive probation cases.
Got it. Okay. Thank you for that.
No problem.
Now let me turn. Thank you, Mr. Adams, for your patience. Share with me, please, what you want to share about Mr. Way's situation.
Well, Mr. Way from day one is denied having anything to do with this. It stayed firm on that. I'm not sure on the 15SC, what were the charges on that?
It is a possession of cocaine with intent to distribute. And Mr. Way entered his plea in January of 2016.
As the record reflects, he has no history of violent acts. He has 4 kids. His fiance is with us today. But over the facts and all, even though they are circumstantial, he thought it was in the best interest to enter a plea. We ask that you accept it.
All right. Mr. Way, we've already had the conversation about an offered plea. I think I find that you do understand how that works. Is there anything you want to add, or have you, through your lawyer, shared what you want to share?
Through my lawyer, shared what I wanted to share.
Do you have any questions about anything anyone has said thus far?
No, sir.
Okay. Mr. Adams, so that we don't need to bring Mr. Way back here for a revocation hearing, do you waive any due process notice rights so that we can handle the revocation in the 15SC case?
We do, yeah.
Okay. And Mr. Way, all that means is instead of me getting you back here in 3 months when probation says, oh, wait, there's a new conviction, this case. Now we're going to try to revoke Mr. Way's probation in that old case. We're just going to take care of all that today. Okay.
Yes, sir.
All right. Mr. Way, I do find that there's a factual basis in this case, meaning if the state was able to put on all the evidence that it shared with me, and I shouldn't emphasize all, the bit of evidence that the state has, A jury might find you guilty, and if they did, because they credited Ms. Hunter's testimony and Mr. Kane's testimony, et cetera, they could find you guilty. I don't know that that would be the outcome, which is why your lawyer has been able to very effectively on your behalf negotiate the state down from what we might typically see in a case where we lost 3 lives. But it's here not the number of lives so much as the lack of evidence on the state side that I think gets us to this offered plea. But I will accept it. I find that your plea is knowing and voluntary. Voluntary means no one's forcing you to enter the plea. Is that correct?
Yes, sir.
And a knowing plea simply means you've understood everything we've talked about. You told me that. Mr. Way, part of your sentence will be on probation. When you are on probation, you'll be subject to the Probation Options Management Act. What that means is that if you have a small violation of probation, we call them technical violations, those will be handled by probation. You don't get in front of a judge. But if it's a more serious violation, you get arrested again, or you're around any of the Watkins's family or Mr. Hall's family, that'll come back to me and we'll work through what ought to happen with that. Mr. Way, normally, I say normally, back in the day, we used to hand the indictment around and you'd sign indicating your offered plea to just the 4 counts, all the other counts being dismissed. Mr. Adams would sign, et cetera. But we're trying to do that electronically now, so less paper moves around. Do you authorize my staff to sign the indictment indicating your offered plea to the 3 reduced counts and the amended count?
Yes, sir.
Mr. Adams, may we sign for you?
You may, Your Honor.
And Ms. Jones-Connor?
Yes, Your Honor.
All right. Mr. Way, what I am going to do is sentence you on count 1 to a period of 20 years to serve 7 years, 3 months, and 8 days. The balance will be probated. Count 2 and 3 are both going to be 7 years, 3 months, and 8 days. Those will run concurrently with count 1. And the final count, count 16, which has been amended to 16-11-131B, Bravo, will be 7 years, 3 months, and 8 days. That'll run concurrently with count 1. You will get credit for all the time you've been in. You have been in, as I understand it, since December 3rd of 2020. If it was before that, you'll get credit for that. But I just looked in the system and it looks like that's when you got arrested. And I know you haven't gotten out since then. In light of this conviction, I will revoke your probation in 15SC179614, which happens to be 7 years, 3 months, and 8 days. And that revocation will run concurrently with, meaning at the same time with, your sentence in this case. So that case will be closed out when you are paroled, which is probably what will happen first before your probation starts. And then you will be on probation. 2 special conditions of your probation. 1, no contact, direct or indirect, with the families of Cortez Watkins, Bernard Watkins, and Alfonso Hall. And then 2nd, you will be subject to a 4th Amendment waiver, which simply means if you and probation are having an interaction and they say, hey, I need to see what's on your phone, if they have a reason to suspect what's on your phone, they can look at that without a warrant, or they can search your house or something without a warrant if there's a reason they want to check things out. Ms. Jones-Connor, anything more from the state?
Nothing further from the state, Your Honor.
All right. Ms. Tucson, I assume you don't need any reporting instructions because Mr. Way isn't being released right away. Is that correct?
That's correct. It's usually given within the facility. They'll have his information. They'll give him reporting instructions to Atlanta.
Got it. Okay.
Or wherever he will be living. They'll coordinate it.
Okay. Mr. Adams, anything else on behalf of Mr. Way?
Yeah, just clarification on his probation. What was the sentence in 2016?
It was 20 years to serve 5 with the balance on probation, but those 5 were reduced to time served. That was on count 1. The other counts were concurrent with, except one, there was a firearm during commission of a felony that was 5 years consecutive, but it was suspended. So it was 15 years probation, basically. And Mr. Way was a little more than halfway through that. All right. For the families of the Watkinses and Hall, again, none of this brings anyone back. It doesn't heal, but it is in one respect closure. You don't need to come back to court again. Mr. Way has brought this to a close in a manner that doesn't involve testimony or autopsy pictures, no appeals. So in that way, a chapter is closed. I appreciate your continued support and involvement in the process. I know it hasn't been easy. And Mr. Way can tell you better than I have, it has not gone quickly. These things ought to move a little more quickly. Obviously, COVID got in the way of movement for a while. And then there were the negotiations between the two sides. And Mr. Adams, I want to thank you for your representation of Mr. Way. Thank you, everyone.
Thank you.
So Ms. Nelson, I'm going to end this Zoom session because I have a civil one that I think is a different Zoom session. I think you set up yet another one for our afternoon. Is that correct?
That is correct, Judge.
Thank you.
You're welcome.